Today, folks, we have a special treat for you. I'm presenting my entire speech that I gave just this week to the 2024 Federalist Society National Lawyers Convention. A very big deal. A lot of federal judges in attendance, a lot of law clerks, lawyers, intellectuals, scholars, and the like. So check out my speech. It's going to get geeky. I was speaking to, again, a very legalistic audience, but I think you will enjoy it, and a lot of it will sound familiar. And there's some new stuff in here, by the way, some new ways to protect our right to keep and bear arms against the anti-gunners. Check it out right now. Good morning. Today I'm going to talk about the framework that lower court judges must apply when they are applying the Heller-Bruen methodology of interpreting and applying to modern-day gun control laws the Second Amendment. Now, as we know, many lower courts, for those of you who watch my channel, the Four Boxes Diner, which has been viewed 43 million times today in the last couple years, you know that I do take criticism with many of the lower court judges who have perhaps gone awry in their approach and application of Second Amendment jurisprudence. But there do appear to be two particular areas where you see an inordinate number of mistakes by lower court judges. The first is what constitutes a suitable historical analog law in the first place. And the second is, how does one derive from those historical analog laws a principle that constitutes some sort of historical tradition of firearms regulation, which lower court judges are supposed to find in the context of figuring out if there's an exception to the unqualified command of the text of the Second Amendment. And again, it's very important to start off with the text of the Second Amendment, not as sort of a administrative ministerial task, but it's because the U.S. Supreme Court has specifically said that the text of the Second Amendment is an unqualified command. Now, this is very important to understand. Why? Because when you read newspaper articles or you read comments that go along the lines of like, I don't understand history. History is too hard for me. I'm not a historian. Guess what? If there is no historical tradition of regulation, if there is no history, there is one bit of history that is undeniably there, and that is the text of the Second Amendment itself that is literally in the Constitution, which is indeed the definitive historical law, the historical analog, if you will, of the views of the founders as to how they viewed the right to keep and the right to bear arms. It's in the text itself. So anyone that says, I don't understand history or we can't find history, the answer is, well, then if you can't find the history, read the text of the Second Amendment, apply, and rule against the government. Now, let's assume, though, that you're representing the government and the government says, oh, yeah, we want to justify some modern-day gun control law. Okay, so how does the government go about doing it? And what can they do? What can they not do? To begin with, they are supposed to, of course, as we know from Heller and Bruen, and remember, Bruen is really just Heller with a paint-by-numbers approach. Heller and Bruen are the same methodology. The only difference is that Bruen spelled it out to try to get the lower court judges to follow the Heller methodology of look at the text first, and then shift the burden to the government to find some sort of historical analog exception to the text of the Second Amendment. But the government cannot engage in that approach to finding historical analog laws and deriving a principle if the Supreme Court has already done the historical spade work in a particular case. For example, in Heller, the Supreme Court has already done the text analysis and the historical analog analysis to conclude that in an arms ban case, you cannot ban firearms that are in common use by Americans for lawful purposes. So all these lower courts that decide they want to go off and reinvent the wheel and they want to invent and come up with new excuses to not justify, let's say, bans on AR-15s, or they want to justify these bans, they pretend that Heller is no longer good law. But my count as of yesterday was the Bruen decision cited favorably the Heller decision over 100 times in the majority opinion. So again, if the Supreme Court has already determined the historical principle, they've already determined the constitutional test, the lower court only needs to apply that test. It doesn't get a second bite of the apple to go out and do more historical work. But let's assume that the Supreme Court has not actually done the work yet, and the lower courts have to do the work now. What is the government lawyer's burden to do once the burden has shifted to them to justify a modern-day gun control law? Well, there's really three basic things. The first is they have to come forward with relevant historical analog laws. Second, they have to derive from those laws some sort of principle. And then they have to apply that principle in some way to justify the modern-day gun control law to show it's justified. And if they fail in any one of these three criteria, the government loses, the right to bear arms prevails, and the gun control law goes bye-bye. So how does one start with finding historical analog laws? Well, there's a number of rules that have been set forth by the Supreme Court, which the court has referred to as metrics. The first metric is, or rule, is this. To have a historical tradition of firearms regulation, you have to start with actual laws, right? And this is, again, you see this, I see this all the time in commentary and among judges. Again, it goes back to we're not historians. We don't understand history. We don't have a PhD in history. Come on. The right answer is the only history that matters is historical laws. Who actually has experience in looking up historical laws and applying them to modern-day controversies? Oh, that would be every lawyer in America, right? By definition, lawyers go look in the past, find laws, and apply it to your client's advice today or to a case today, whatever it is. The entire practice of law is looking back in time to what happened at the crosswalk on that day, at that time. What is the law that applies? All this is looking into the past. So the suggestion that lawyers cannot do history is simply absurd and an excuse by certain judges to try not to do the work they're tasked to do with the Supreme Court. So again, the first thing is it has to be a law. It cannot be just some generic history or some proposed law that never became an actual regulation. Number two, it has to be from the right time period. Yes, the Supreme Court has made reference to an academic scholarly fight between whether or not the relevant time period for interpreting the Second Amendment is 1791 when the Second Amendment was ratified, or 1868 when the 14th Amendment was ratified, but it's pretty clear the Supreme Court is going to apply the founding era of 1791. To begin with, Heller specifically says so. This is what Heller writes, quote, "Constitutional rights are enshrined with the scope they were understood to have when the people adopted them." When was the Second Amendment adopted? Not hard, 1791. That is the understanding that controls. And for those of you who question whether or not the Supreme Court will deviate here, I'm just going to direct you to the Supreme Court's decision a few years ago in Espinoza versus Montana, dealing with the religious liberties clauses of the First Amendment, part of the Bill of Rights. And in Espinoza, Chief Justice John Roberts, writing for the majority, rejected, listen carefully, rejected 30 statewide laws that restricted certain aid provisions, restricted aid to public schools or religious schools. He rejected those as being too late in time in interpreting the First Amendment. If John Roberts, Chief Justice John Roberts, is going to reject 30 state laws from the late 19th century as not a basis to limit the scope of the First Amendment, I can assure you they're not going to use late 19th century post-14th Amendment laws to limit the scope of the Second Amendment when push comes to shove. The third rule in terms of whether or not an analog is it cannot be racist or otherwise be founded in something that is unconstitutional. If you look at what the Joe Biden administration's Department of Justice, no friend of guns, no friend of the right to keep and bear arms, they embraced racist laws in the U.S. Court of Appeals for the Fifth Circuit in Rahimi. They get before the U.S. Supreme Court and surprise, surprise, they drop it. They don't argue it. And this, of course, is the right answer, which is exactly what Justice Kavanaugh noted in his concurrence in Rahimi, where he writes that courts must exercise care not to rely on the history that the Constitution has left behind. Racist laws, anti-Catholic laws, all of these things are the sorts of things that cannot serve as an analog in limiting the scope of the Second Amendment right. Now, the fourth rule as to whether or not an analog can be an analog in a Second Amendment case is the analog well established? Is it a representative example, or is it what I would call an outlier? We know based on Supreme Court precedent that laws that are only in existence for a very short period of time or that did not affect a substantial swath of the American population do not establish historical traditions. One need only look at what the Bruen court said, and they say, quote, "We will not stake our interpretation of the Second Amendment upon a law in effect in a single state or a single city." Now, the court did not specify the number of quantum of laws, the quantity of laws to justify a tradition, but it did say that 3 analog laws are not enough. And it's also worth mentioning when you're dealing with territorial laws, those are also a no-go zone for deriving an analog, because as the Supreme Court said in Bruen, the territorial laws are not suitable analogs because they were enacted over a century after the Second Amendment. They only apply to maybe 1% of the population, and they were never subject to judicial scrutiny because they did not have the ACLU fighting for cowboy rights in the Western territories. So one doesn't actually know if they would have been found constitutional if they were ever challenged in court. Now, that's the first thing. If an analog violates anything I just said, it's a no-go, you can't use it. But let's move on. Let's assume you still have a basket of analogs or proffered analogs by the government that's still in play. You now need to move what I call to the relevantly similar part of the analysis. Relevantly similar gets into, does the why and the how of the analogs you have put together line up with the why and the how modern-day gun control laws exist? Now, what does this mean? I think there's a lot of abstract theoretical discussions we could have, but rather than do that, I want to be very precise and ask what the United States Supreme Court has done dealing with these issues, because I think they really do illustrate how you do the why and the how. In Heller, for example, that was a case involving whether or not the District of Columbia's gun ban, handgun ban, was constitutional. After the court in Heller found textually that the Second Amendment protects all bearable arms, and thus DC's law was presumptively unconstitutional, they looked to see if there's a historical analog set of laws at the time of the founding that would justify DC's gun ban. And they found that they could not find any sort of historical tradition. First of all, let's talk about the whys. The whys. DC proffered a law at the time of the founding out of Boston and some other cities that said that you could not have too much quantum or too much of black powder in the home. And DC said, see, there you go. You need powder for firearms. Boston limited the quantum of gunpowder in the homes, and therefore, by extension, we can ban handguns. But obviously, the Supreme Court said that's a no-go. Why? Because the whys, the purposes of the laws do not line up. The black powder storage laws by Boston in the 18th century was about preventing fire from burning down an entire city made of wood, whereas DC's gun ban was about the why or purpose of stopping criminals. And the Supreme Court says the whys don't line up. That doesn't help the government prove its case. But it goes beyond that. There was a set of laws that the Supreme Court found somewhat analogous that could be considered, and that was the laws that regulated what would be considered dangerous and unusual arms. The Supreme Court said there was a tradition at the time of the founding of banning or regulating dangerous and unusual arms. But then the Supreme Court moved on and extended that out and says, as a consequence, because handguns in America are ubiquitous and are the most preferred means of self-defense of Americans, guess what? They can't be banned because they're in common use by Americans for lawful purposes, and as a consequence, they are not dangerous and unusual. The DC gun ban falls by the wayside, even though the Supreme Court identified a historical set of analogs that justified the banning of dangerous and unusual weapons. But when they applied that principle to the facts of that case, they found that the government, again, could not justify the modern-day gun control law. Now let's turn to Bruen. How did Bruen deal with these historical analogs, with the how and the why? The Bruen court, of course, did something very similar. The big argument that was made by New York to justify their May issue permit regime, which was basically saying if you want to get a handgun to protect yourself in public, you have to go mother may I to licensing officials and say, please, 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 I'm a special person, give me a gun permit to carry guns in public and exercise my right to bear arms, which of course means to carry guns in public. And the Supreme Court struck that down as unconstitutional. And why did they do that? Because there was no historical tradition of banning the carrying of guns at the time of the founding. So New York proffered a set of laws that says that you could ban concealed carry. Listen carefully to this. You could ban concealed carry at the time of the founding in many states. That was the argument by New York. But if you look carefully at that, in every state where you could ban concealed carry, those exact same states always allowed for open carry of firearms. In other words, if you look at the how the right was burdened in Bruen, those laws that prohibited the concealed carry of arms was a burden on the mode by which you carried the gun, not the actual carrying of gun in public for self-defense. Because in those states where you could be banned from concealed carrying a gun, you could open carry a gun, effectuating your right to bear arms in public for self-defense. And the Supreme Court thus rejected the New York law in that context because the New York law banned all modes of carry, both open and concealed, and distinguish those laws proffered by New York as not adequate, because the how the law was burdened was different from what the how the New York law did versus the how it was burdened by those laws banning concealed carry at the time of the founding. And finally, let's talk about Rahimi. Okay, this is the baseline understanding of Rahimi. Rahimi is the first example of what I call a routine Second Amendment case decided in a routine way. If you think about it, if you're Thomas Kuhn writing about paradigms and scientific revolutions, I would argue that metaphorically, Heller, MacDonald, and Bruen were sort of part of a scientific revolution in terms of articulating a Second Amendment framework in an originalist methodology. It really lays out the rules of the road. What makes Rahimi kind of interesting and special is that it's the first example of an ordinary case being decided by virtue of what had prior to that been a scientific revolution in Second Amendment jurisprudence. So what really Rahimi is ordinary science. It's an ordinary people doing ordinary science after the occurrence of a scientific revolution, and that's what Rahimi is really about. It's just an application of all the groundbreaking work the Supreme Court had done in the prior Second Amendment cases. Now, with that said, I think Rahimi is just the basic application of Bruen and Heller, because if you look at it, the how and the why are clearly satisfied. Both the how and the why were satisfied because there were two sets of laws that were so ubiquitous. I think they were referenced in both Blackstone and Hawkins. So we're not talking about any kind of outlier laws. These were the surety laws, which is a civil law that ahead of time said that if someone is found by a court to be a threat to engage in violence against somebody else, they could be forced to post a bond or get sureties, obviously finding of somebody being dangerous. Likewise, the going armed statute said if you use a firearm to go armed and threaten people and terrorize people, you can go to prison, and the Supreme Court said that the why is satisfied by those both historical analog laws, because again, the affray law said if you actually misuse a firearm, and the surety law says if it looks like you're going to misuse a firearm in a finding by a court, the whys are the same because the why is to stop somebody from misusing firearms going forward into the future. And the hows are very similar because it restricts the ability to possess firearms, either because they put you in prison because you violate the going armed laws, or they make you post a bond. And if you can't do that, they put you in prison, I believe, under the surety laws. So either way, you're looking at the how and the why are lining up to prevent and by the way, the holding of Rahimi is extremely narrow. If you think about it, all Rahimi holds is this. If there's an actual court finding that you are a danger to someone else, you can be temporarily disarmed. Look at all the qualifiers there. There's got to be a finding by a court that you're bad and a danger. It's only temporary disarmament, and that's really all it held. It doesn't get into due process or anything else because Mr. Rahimi admitted that he was a danger, admitted to the entry of this, didn't waive his due process rights, so none of those issues were presented in Rahimi, and I'm sure they will be presented in future cases. Now that I've just shown you what violates the rules and cannot be analogs, and then I've shown you how to deal with the how and the why, which is really another metaphor for deriving the historical principle of a case to apply, I want to get into something that I don't want to call this new because the Supreme Court talked about it, but it's something new today, and that is the 5 or 6 approaches to stopping a too high level of generality. One of the concerns that people have posited, including Justice Barrett, is that you can always derive a principle from historical analogs at too high a level to eviscerate the Second Amendment right. For example, every law ever enacted, guess what, is in the name of public safety and security, right? So, but you can't just say just because a law was enacted for public security, that justifies all modern day gun control laws today. The Supreme Court has repeatedly rejected that. That's exactly what Justice Barrett raised as a potential problem, though. So I'm now going to posit a series of third rails guidelines that says that if the principle that you derive from your analog, from your historical analogs and the principles derived from those analogs, if they violate any of what I'm about to say, they're no good. The principle must be rejected because it's too high of a generalized approach. The first is if it violates the directly contrary to the Second Amendment's guarantee of the right of the people to keep and bear arms, it is too high. Judge Kavanaugh discussed this in Heller 2 when he was on the D.C. Court of Appeals when he wrote that, quote, post-ratification adoption or acceptance of laws that are inconsistent with the original meaning of the constitutional text obviously cannot overcome or alter that text. So to the extent that you're deriving a principle that will alter the Second Amendment text, that is not allowed, as now Justice Kavanaugh pointed out in Heller 2 on the D.C. Circuit. Number 2, The historical principle derived or alleged to be derived by the government cannot violate Supreme Court precedent. So if there is a principle derived by historical analogs today by the government in a case that would violate, let's say, the Heller holding on in common use firearms cannot be banned, that is also a principle that means that the historical principle argued for by the government is too high a level of generality and cannot be accepted. Third, if the derived principle cannot, and this is key, the derived principle alleged by the government cannot come from the perspective of criminal misconduct or the perspective of the criminal. What I mean by this is if you look specifically at Heller, the perspective on Second Amendment rights is how do ordinary law-abiding Americans use firearms. They don't focus on how criminals misuse firearms. We saw that specifically in Heller because Justice Breyer talked all about handguns being used by criminals for criminals for bad purposes. The Supreme Court rejected that mode of analysis and simply said that, hey, all that matters is that Americans value these handguns for self-defense, and that's the perspective. So if the principle derived is all about how criminals misuse firearms, that's a no-go. Likewise, we must keep in mind that the purpose of the Second Amendment, as articulated repeatedly by the Supreme Court, is to protect Americans against all forms of tyranny. All forms of tyranny, and that could be anything from street criminals, could be terrorists, could be animal attacks, as referenced by Justice Kennedy in our argument in Heller. It could also be against repelling foreign invasions, domestic insurrections, and the like. So to the extent that a principle derived by the government violates or eviscerates any of those purposes, that again would be too high a level of generality. And last but not least, I would say that if the proposed principle derived by the government, if applied in 18th century America, would actually turn the American founders into felons, that also is too high of a principle. For example, if you were to buy into the anti-gunner arguments in Bruen, that at the time of the founding, no one was allowed to carry guns, that was verboten, that would mean that every single one of the first 6 presidents of the United States were felons because every single one of them undeniably carried guns all the time from Washington to Jefferson to Jackson and so on. And if the principle derived in a case by the government would somehow turn every founder into a felon, if that principle were applied in the 18th century, that again is not allowed. So simply to close the speech as follows. The Second Amendment, it's important to remember in Second Amendment case, the founders had a lived experience with firearms. They were ubiquitous. They had them everywhere they went. They viewed this as part of being a citizen. And they viewed this as such an important right, they literally wrote it in to the Bill of Rights. So I will just sum up by saying that we must never forget the Supreme Court has called the Second Amendment unqualified right. It is always the ultimate history. If there's ever ambiguity or a question about whether or not the government should win, the government should lose, because it's actually in the text of the Bill of Rights and the Constitution. That should take priority over any airy-fairy history or attempt to limit those rights by government. Thank you.
Orders up. Table 2A.